state, Miss Leslie appears in person and per se. Miss Leslie, is that you?
Yes, Your Honor.
Where's your attorney? Are you going to have an attorney represent you?
I am presenting myself.
You know you have the right to an attorney, to hire any attorney of your choice. If you cannot afford to hire an attorney, you can apply, which I think you've already done, but you did not request an attorney, is that right?
I did not request an attorney. That is correct.
You want to proceed on your own behalf, and you can do that. No one's going to stop you from doing that. But is anyone making you give up your right to an attorney today by any threats or promises?
No.
And you understand you can hire, and if you can't afford, you can apply for court appointed. And if you qualify, one would be appointed. Do you understand that?
I comprehend, yes.
You do not wish to have an attorney.
I do not wish to have an attorney.
All right, I will show on the record that you've waived your right to an attorney and that you're going to proceed on your own behalf. So how do you plead then, Miss Taylor, or Miss Leslie, I guess it is. I'm sorry, I'm just saying it wrong. Miss Leslie, how do you plead to count one, interference with law enforcement officer?
A plead would be inappropriate at this time. I'm hoping to request a continuance.
Why would a plea be inappropriate at this time?
Okay, so Your Honor, for the record, I am Sydney Taylor Leslie in propria persona sui juris. I am here by special appearance only and not making a general appearance. I reserve all of my rights, remedies, and objections, including but not limited to any objection to jurisdiction over my person. I require a continuance in this matter. I intend on filing a subpoena for body cam and cruiser footage. There are facts in dispute.
Before we even dive into today's courtroom chaos, buckle up, because this isn't just one sovereign citizen showdown, it's a full-blown trilogy of courtroom delusion. We're starting with a familiar face, a so-called Karen, who previously went viral for claiming she had the and refusing lawful police orders on the side of the road. That situation ended about as well as you'd expect, with shattered glass, an arrest, and now, a judge who's clearly not buying what she's selling. What makes this case especially wild is how confidently she walks into court armed with sovereign citizen buzzwords, fake legal theories, and a belief that simply saying things like special appearance somehow makes the law disappear. We're about to watch her try to outmaneuver the legal system without a lawyer, challenge the court's authority, and ask for delays while insisting she knows her rights. But here's the twist: the judge already knows exactly who she is, and what she did. And as this hearing unfolds, you'll see
just for you to obtain discovery, but if you don't know how to do the things you just rattled off, you better have an attorney do it for you. Do you understand?
I understand.
All right. Mr. Aguirre, do you wish to be heard before I pick the date for this?
Your Honor, this does appear to be the first setting since the first appearance hearing before Judge Hart back in June. If the court is prepared to set this matter over for discovery purposes, the state does not object. I'm not sure if the court wishes to set that matter for merely control at this time, but I'll defer to the court on that point if the court will find that the bond is being continued and this continuance is at the request of the defense for speedy trial purposes.
All right, Miss Leslie, you're charged again with interference with law enforcement officers, a Class A non-person misdemeanor, driving without insurance, a Class B misdemeanor, and driving without a license in your possession, an unclassified misdemeanor, as well as failing to register your vehicle, another unclassified misdemeanor. The judge would have gone over these with you at first appearance. You want to go over them again as far as the penalties?
No, thank you.
All right. And you've indicated you want to exercise certain rights that you are entitled to and encouraged to. But as I said, an attorney could certainly help you carry out those rights. And you said you do not want that attorney?
That is correct.
Okay. Well, I'll have the record and the docket notes show that you have waived your right to counsel and that you know what you're doing. Now, then, do you want to set it for trial, Miss Leslie, or do you want to get the records and look at them and then set it for trial?
I would like to have a continuance, perhaps for discovery or an evidentiary hearing if possible.
Well, I can continue it for both those readings.
Okay,
For both those readings, to give you time to get all your discovery, the dash cam, body cam things you were mentioning.
okay.
And then we can also set it for trial. So when's a good trial, 1:30 trial date, Jim?
Your next one will be September 24th.
All right, you'll need to be back here with all your witnesses, September 24th, 2025 at 1:30, and that will be by Zoom again.
Your Honor, if I may just get a little more time due to the fact that I'm going to be submitting the subpoena and I'll need discovery, and I need to just review it so that I can have adequate time to present myself for my defense.
Well, that's 30 days. You don't think that'll be enough? How much time are you asking for?
I'm hoping for at least 60 days.
Jen, do we have 60 days?
We have October 22nd or October 29th at 1:30.
Which of those do you prefer?
I would prefer October 29th.
October 29th. This is continued to October 29th at the defendant's request. Is that over your objection or not, Mr. Rigier? I don't remember any objections.
Your Honor, if the court is prepared to set this matter for trial, the state does not oppose that, but the state will be requesting a ruling as to whether or not the bond is to be continued and if this continuance is at the request of the defense.
Court does find this request at the defendant's, and the time will count against the defendant for speedy trial purposes. The matter is continued for bench trial to be heard and to be commenced August 22nd, 2029 at 1:30 p.m. via Zoom. So Miss Leslie, it's going to be here by Zoom. Right, be sure you have your evidence ready. If you're going to screen share it, whatever you're going to do, make sure you can do that. And if you need any help getting your discovery or presenting your evidence, you're always able to hire an attorney. And if you can't afford one, apply, but do it well in advance of the trial so that you can get the application completed, returned, and the court can appoint your attorney, and you and the attorney can have time to present your case.
Okay, yes, Your Honor, I did hear you say October 22nd. Was it the 29th that I had requested at 1:30?
You did, so I'll make it October 29th. Jen, you said
Thank
either.
you.
You said either, and she picked the 29th, correct?
That is correct, Your Honor.
It'll be October 29th at 1:30. Now, Mr. Regier will be subpoenaing witnesses himself for the state. And if you find out or decide you don't want to go with a bench trial, let him know as soon as you can so he can cancel any of those witnesses that he may have coming in.
Thank you, Your
Okay.
Honor.
You're welcome. And don't forget, you can look at diversion and see if that's an option.
And here we go, the moment reality officially enters the chat. The casual YouTube intro fades out, and suddenly we're inside an actual courtroom where consequences exist. Notice how formal everything becomes immediately: case numbers, names, and the calm professionalism of the judge. This isn't social media. This isn't a comment section. This is where legal fantasies usually go to die. What's important here is that the defendant is already known to the court from a previous appearance. That means this isn't some misunderstanding, the judge has context. And when courts have context, patience tends to run thin a lot faster. You'll also notice something sovereign citizens love doing: showing up in person and per se, which is basically their way of saying, I'm representing myself because I think I'm smart.
Jose Elizondo.
Yes,
Mr. Elizondo, you have a motion that was filed, so we will get to that after I take everyone's announcements. I just want to let you know that I do have you here, and I see that you're here, but I'm gonna take the announcements first, then we'll get that heard. All right, so if you can just stay logged in, we'll get you processed through promptly, all right?
all right.
Okay, thank you. All right, Mr. Bishop, we have two defendants with motions, and then we have one defendant set for trial. All right. So the first case set for motion is Jose Elizondo. Mr. Elizondo, if you can please unmute and show your video.
I'm here.
Okay, thank you. So, Mr. Elizondo, you had a pretrial hearing earlier this year in May, and then after And at that hearing, you had indicated that you had mailed in a motion for a bond and that was the only motion that you had. And we did not have that here. After the court, and we set your case for a jury trial on August 28th. Then after the date of your pretrial hearing, we received a motion in the mail stating defendant's Rule 91 motion to dismiss for failure to state a claim upon which relief can be granted. Mr. Bishop, have you received a copy of that motion?
Your Honor, and made a response.
Thank you.
I believe he's filed 2 motions. I've got a.
Here it is, the classic sovereign citizen maneuver. Instead of answering a simple question, how do you plead? She dodges it entirely. This is a textbook tactic pulled straight from internet forums that claim refusing to enter a plea somehow breaks the court's authority. Listen carefully to the buzzwords she starts throwing around: propria persona, special appearance, reserve all rights, objection to jurisdiction. These phrases are designed to sound legal, but in real courtrooms, they don't carry the magic power sovereign citizens think they do. Judges hear this stuff constantly, and it never works. What she's really doing is trying to delay the process and avoid accountability by turning it into a procedural circus. And while the judge allows continuances when appropriate, you can already hear the skepticism creep.
Questions. You need to summarize your motion at this time.
All right. Well, I just want to add to my motion that according to the Texas Transportation Code, Title 1, Section 502.003 clearly states it prohibits political subdivisions from requiring registration, and my violation was due to registration. So that's all I wanted to add, and I plead not guilty and for dismissal too.
Mr. Bishop, your response?
Yes, I addressed this in my response, Your Honor. The city of Dalworthington Gardens is the political subdivision of the state of Texas. And this registration requirement is not a violation of a city ordinance. There is no city ordinance that requires individuals to register their vehicles. That's state law. And so the defendant is incorrect in applying that statute because it's a state law violation, not a city ordinance violation.
The court has read the defendant's motion to dismiss, and I have read the state's response to that. And the court is denying the defendant's motion to dismiss. I don't see where you prepared an order for me to sign. Let me see.
I did not prepare one, Your Honor, but I will be glad to prepare one.
Okay, if you can prepare one, Mr. Bishop, I will get that signed. I'm writing a notation here. Motion denied. Right. And then we have the second motion, defendants, no consent given. Mr. Elizondo, you may summarize your argument at this time.
Whatever I submitted is what I plead to continue with.
Mr. Bishop, we should summarize the state's response.
Yes, the state's response is in the state of Texas, driving is a privilege, not a right. And by exercising his privilege to drive on a Texas highway or street, he is subject to all rules of the road, statutes and rules. And so the state does not need his consent for him to be subjected to jurisdiction when he has violated a state law. He's not being denied.
Now that line right there is brutal and unintentionally hilarious in a dark way. The judge isn't mincing words at all. He flat out reminds her that she refused lawful commands and literally ended up eating glass. That's not courtroom sarcasm, that's a factual summary of her own actions. This is what happens when someone records themselves acting out and thinks it proves their innocence. Instead, it becomes Exhibit A for the prosecution. Judges aren't impressed by viral clips when those clips clearly show someone breaking th. Can also sense the judge's tone shifting here. He's still professional, but the patience is thinning. He's essentially saying,
Response by the state has considered the arguments made here in court, and the court is denying the defense statement of no consent given to jurisdiction. Okay, so Mr. Elizondo, your case is set for jury trial on Thursday, August 28th at 8:30 in the morning. That is when you need to be here. You have cited in some of your motions civil rules of procedure. As I have warned you before, I'm warning you again, the Texas rules of criminal procedure apply in this case. This is a criminal charge, and you need to follow the Texas rules of criminal procedure. You will be expected to follow proper courtroom decorum, and as you are representing yourself, you will be held to the same standard as if you were an attorney. You will need to be here at 8:30 in the morning. You will receive information regarding the venirmen, the potential jurors, and voir dire will start at 9 a.m. You will be given 15 minutes to ask relevant questions of the venire panel. The state will be given 15 minutes to ask questions of the venire panel. Each side is given the opportunity to make up to 3 strikes, and then we will proceed to the jury trial that day. Have any witnesses that you wish to call and any evidence that you wish to present here and ready when you get here at 8:30 in the morning. Do you understand, sir?
Yeah.
Okay. All right. Mr. Elizondo, is there anything else that you wish to put?
here's where the situation gets real serious. Up until now, it might feel like a procedural back and forth, but listen to the list of charges. Interfering with law enforcement, no insurance, no license in possession, failing to register the isn't one small technical issue. This is a stack of violations. And that's another pattern with sovereign citizens, it's rarely just one charge. Their ideology